Well, Henshaw here for the Constitutional Crisis channel. Had a little bit of a break in between from the last videos, but we're going to catch up in a hurry here. First one today is kind of current events, more or less, something you won't particularly be aware of unless you're following my videos. But I have one of these current infamous red light camera tickets going on, and the case is already won. They're just too damn ignorant on the other side to even know that yet, but it is. We got a quote-unquote trial date, February 2nd. Same day Punxsutawney Phil comes out of hiding. And never going to happen. But the interesting part for you is what's going on here, because I follow my own program, as you might expect, and we hit them from day one with the demand for a bill of particulars, which is what you should be doing. And we sent that to the DA to be filed and to the clerk of court to be received, along with a notice of denial of counsel. That's not a moving paper. It's not a motion. We're just saying this is what the law is. We're telling you what it is. And we sent that to the DA and to the clerk at the traffic court, who's been very good about returning things. We send self-addressed stamp envelope, send it back to me, conform, file, stamp it. Haven't gotten them back. 3 weeks. 10 days ago, I sent the 62-page subpoena in a red light traffic case. 62 pages. And they can't answer one paragraph. They won't be able to do it in your case either. So we sent that, and here we are on the 11th, and I'm not upset about it yet, but we haven't heard a word and haven't gotten any conformed copies back, nothing. So in my own mind, given this girl who's had a very good track record there, I'm saying to myself, has she been ordered by somebody higher in the food chain to not file these documents we're sending? And if so, who is it? And if so, on what authority denying us access to the subpoena power of the court? That's where we get our defense in, because among other things, and we don't have one here with the red light camera ticket. Guess what? You don't have an arresting cop that can identify you and say, yeah, you did it. Not there. Got a damn camera which you can't confront and cross-examine. If we had one, we'd be putting, in fact, I may in this case put in a subpoena for the camera. But who knows? But point is, if you can't get your accuser in there, that's a violation of confrontation and cross-examination. And although they don't think so at this moment in time, this is a criminal proceeding here. It's exactly what it is. And I've got the California Supreme Court, believe it or not, and the Court of Appeals saying the same thing in unpublished opinions that you can't use unless you know about them and do your homework like I do. Well, it's criminal. So therefore, we have every right to subpoena in the cop as our own witness. And it's very important, because you go to the traffic, quote-unquote trial with the traffic commissar there, and no DA in California, and he asked the cop questions about who did what, this, that, and the other, and then he turns questioning over to you for cross-examination. You will be limited to asking the cop only questions about what he testified to in direct testimony. Anything else that goes beyond that, they're going to say, sorry, you can't do it. That's not cross-examination. That's why you subpoena the bastard in as your own witness. And now you can sit there and ask him questions about how he got a hold of that particular job, how he was trained, and a lot of other embarrassing questions they're not going to want you to be able to ask. But as your witness, you can do it and set the record that he's incompetent to hold the position and has no authority over you. That's a big part about this, and I think bottom line is, this is why, if the girl was ordered at the traffic court not to file these documents, this strikes me as a very probable reason for it. Now, they can't come out and admit that, at least you wouldn't think they would, and tell you can't put a defense on, just show up, pay up, and get the hell out of here. I mean, that's how it works. It's not how they want you to think it does. So there's still more going on here, and I'm holding up filing a writ with the California Supreme Court until these details sort themselves out. If I haven't heard anything by 2 weeks from today, which will be Christmas, oddly enough, probably the Supreme Court's going to get the writ the next week, before the first of the year, and 5 weeks before the quote-unquote trial date, and we'll see what shakes out here. Even if we go to trial, it doesn't matter, because they can't bring anybody in there that can identify my friend as being the driver of the vehicle who allegedly ran a red light, which didn't happen here, but that's a separate issue. So they're going to have to dismiss it. And we could have done that at arraignment, but my friend, knowing that we're already 3-0 against these idiots this year, and we're going to be 4-0 in 1 year, decided to play along here and string it out and see if we can get a much bigger win. And if we do that, especially in California, as soon as that hits the books, you can use the same case and say, here it is, res judicata. I don't care whether you're in North Dakota, Louisiana, whatever. The law is the same. If they're criminal cases, this is what they have to do, and they're not doing any of it because we're not showing up timely and asking them to do it, and their damn state bar licensed attorneys aren't going to do it even if they know. This is where the conspiracy is, because if we have a right to assistance of counsel, as I always say, effective assistance of counsel, this is what they should be doing, but they don't do it because it keeps everybody in business, it keeps them in business, and it keeps them in control of the processes of the quote-unquote court, courtesy of the state bar monopoly on the practice of law. That's what I call an irreconcilable conflict of interest, even if that right of counsel is otherwise available. And those of you who have listened to my videos know it's not. Then you can't use them anyway because of these conflicts of interest, and because they show up, it's a general appearance and a stipulation to the jurisdiction you're trying to challenge. Can't be done. This beats them with hoist them on their own petard, they used to say in the French Revolution. They got nowhere to go because this is the only issue they think has any importance whatsoever. And that's how we're going to beat them badly in this case, and maybe get rid of the state bar monopoly in the state of California, and maybe 50 of them at one time, which is pretty good odds. That's what I'm working toward, and as events develop here, I'll give you updates. It may not be anything for a couple of 3 weeks until I can pin down the fact that we haven't received copies back and that they haven't been filed. Someone's going to pay the price for that. So stay with me here, and I'll report back when I have news. Thank you.